Mark, for holding this very important hearing with Ranking Member Garbarino. As previously stated by my colleagues, cyber attacks are one of the biggest national security challenges that our nations face. And I am dedicated to working with all of you in finding solutions that mitigate these threats. I think one of the biggest challenges in addressing and understanding cyber attacks is encouraging entities to come out of the shadows and report these incidents to CISA. There seems to be a fear that these stakeholders, that they could be unfairly blamed for these attacks. And as a society, I think we do not blame the store clerk when a business is robbed by a gunman. We blame the perpetrator and we work to bring them to justice. So I think our society must take the same approach when organizations report cyber instances and stop blaming victims for taking the correct actions to address these attacks. So I've got some questions. I want to follow up on something that Mr. Bouchard said, but I'll get to that. The Federal Information Security Monitorization Act of 2014 requires the OMB to define a major incident and directs agencies to report major incidents to Congress within 7 days of identification. The legislation we are discussing today would require the director to determine the timeframes, but no earlier than 72 hours. And I think there's a disconnect between the way the federal government and the private sector report. So what I would like to know is whether this 72 hours or this 7 days is the appropriate period, and or is it something else in between? I think Mr. Bouchard, you said that 72 hours was probably sufficient, but Mr. Miller, if I could get your input on that, and I would also actually like to hear from each of the witnesses what their thoughts are on that time frame. What should the appropriate time frame be? Thank you. And if I could go in with Mr. Miller first, and then alphabetically, Ms. Hogsett, Mr. Mayor, and Ms. Denbo.
Thanks very much for the question, Representative Clyde. Yeah, well, as we say in our written testimony, and as our policy principles indicated, and as I think we've heard from several other witnesses today already, it does seem like 72 hours does hit the kind of the sweet spot, if you will, for a variety of different reasons. You know, I don't want to be duplicative of some of the other points that were made here, but you know, just to put a fine point on something, you know, whether we're talking about the Cybersecurity Information Sharing Act of 2015 and the information sharing under that act, or if we're talking about incident reporting requirements here, you know, the goal of these hopefully of these bills and laws is not to just share the information or just, you know, provide an avalanche of information or as much as possible. We really do need to report information in a way that is going to be usable not only by CISA, but by critical infrastructure, by other companies such as FireEye that are working you know, on the front lines of these incidents. So 72 hours seems to be the amount of time that many cybersecurity professionals say is sufficient to determine what has occurred and to provide some of that additional contextual information that's needed, you know, to conduct investigations, to actually make sure that you know, cybersecurity, that you're actually also paying attention to trying to shore up your systems and avoid further damage. And also, okay, it does seem to be in line with a kind of a global standard, if you will, in the 72 hours time.
Well, thank you. Ms. Hogsett, do you concur with that?
Sure. I think what we're all trying to do is we recognize the benefit and the value of providing more information into a central place in the government, in this case, CISA, to help everybody else sort of avoid attacks if it hasn't already hit them, for instance. So what you note around FISMA and the 7-day, I would have to go back and look specifically at when that timeline kicks in, because we've often found in industry when the clock starts ticking can be very different. We believe, as structured in this legislation, it does allow, as John noted, a reasonable time period for a firm to do initial investigation without interfering with that important work that needs to happen, while still providing then useful information that could benefit others. I think the larger point that you highlight, though, is that we do have already in place varying different standards, and there is a need to ensure that there's harmonization. Industry certainly faces this. We have it with our existing regulations. Government agencies are likely also now, as you highlight, to have to face that. And so this is something that we would encourage and would love to continue working with you and Congress on to help ensure that there's more of a standardized baseline and that everyone has a clear timeline and a clear set of expectations around reporting.
Okay, thank you very much. Mr. Meyer?
Yeah, so I'll be quick here just to add. I think I'm looking for the language. I can't find it right now, but two things. One is the legislation recognizes that there's a balance between the agency's desire to get situational awareness and to get information out that could be useful, and the desire of a company to feel that they have some sense of what happened. And again, going
Right.
back to what constitutes confirmation, you're going to know it. If you've got a serious cascading impact on critical infrastructure, you may not know attribution, you may not know all the elements, all the systems that have been impacted. You'll know you're dealing with a significant incident. So I think you accomplish that balance. The other thing I would add, and again, I'm looking for it here, in the Executive Order 14028 that the White House issued on improving the nation's cybersecurity with respect to what federal agencies are required to do and their contractors, they established, subject to check, I believe 3 days as the timeline for providing information. So I'm sure a lot of thought went into that, discussion with other agencies. And as it was pointed out, I think there are general standards around that time. So it's a reasonable amount of time. I think if you tried to make it 7 days, I think a good case could be made that things would be, at that point, too far down the road in terms of potential damage. So
Okay.
I don't think anybody on the industry you're going to find anybody arguing for that amount of time.
All right, thank you. Maybe we should tighten up the federal government's requirement then. And lastly, Ms. Denbo, do you concur with that? I saw you shaking your head, yes.
Thank you very much, Congressman. There's not really a good answer to exactly what the right number should be. Should it be 72? Should it be 70? Should it be 68? It's more of the key is that they are allowed to confirm first that they have an incident rather than just speculating that they have an incident. By giving it the 72 hours, now you're allowing the operator more time to gather valuable, useful information rather than just spitting information to CISA, where CISA is going to come back and ask more questions anyway. So it just allows that little comfort zone and space to be able to do the investigation that's needed to be able to provide preliminary information.
Well, thank you very much. And Madam Chair, I see my time has expired, but I appreciate the witnesses' information here. It's my intent that we have good industry input in the rulemaking process to establish this bill because I think that's very, very important. So thank you, and I yield back.